Hello, everyone, and welcome to our continuing series of Employee and Labor Relations webcast training. My name is John Klea, and I'm a Labor Relations Specialist with Partnership in Labor Relations here at the U.S. Office of Personnel Management. Partnership in Labor Relations provides guidance and policy in the areas of federal employee accountability and labor relations. Today's session is part 1 of 3 in the series entitled Overview of the Federal Service Labor Management Relations Statute. This training series is based on the Labor Relations Professional Development Series 1, developed by the Employee and Labor Relations Network. I believe that you will find this to be a very informative topic. I will present an overview of the statute and labor relations for the first hour of the webcast and leave time for questions towards the end of the broadcast. If you have questions for me, you can send them to plr@opm.gov. Again, plr@opm.gov at any time during the session. I may not be able to address all of the questions simply because of time available. All right, as I said, this is an overview of the Federal Service Labor Management Relations Statute. And on our first slide, we see a reference, USC. And for those of you who are not attorneys or are not familiar with that acronym, that stands for the United States Code. Before we get into the nitty-gritty of the slides, I want to be sure that you have your copy of the Federal Service Labor Management Relations Statute in front of you. Some of you may have this one, which is the little white book that was referred to in the announcement, and that you have your agency's collective bargaining agreement in front of you. We will make use of both of those documents as we proceed with the training. Our course objectives are as indicated on the slide. And I do want to say this is a basic course. There are some things that, for want of time, we simply can't get into in depth in the time we have allotted, such as negotiability procedures in case law, bargaining or how to bargain a labor contract, or contract administration with all of its nuances. There simply isn't time to do those topics justice. Now, the Federal Service Labor Management Relations Program. Well, this slide really introduces you to the things and the topics that you need to know and that you should look at as often as you can, study as often as you can in order to be really a good, sound labor relations specialist, or to understand the statute as it affects you if you're a manager or a supervisor. And some of those things are, as indicated here, the code itself. Again, if you have your copy, that would be 5 United States Code Chapter 71. And that statute is applied and interpreted by the Federal Labor Relations Authority, or the acronym that I will be using is the FLRA. And it does that in a variety of ways. The FLRA issues regulations under the statute, and those provide us insight into the various topics over which they have jurisdiction. And they also issue cases, and those cases involve a variety of topics, perhaps negotiability cases or arbitration cases. And I can't say enough about the fact that in order to understand federal labor relations, you simply have to read the cases that are close to the issue you're dealing with, study them, and decide for yourself what they stand for and how they would apply to the issue that you have to work on or to decide. Now, the other big document, and you can't possibly know federal labor relations and deal with issues and give proper and sound advice unless you have your collective bargaining agreement and you know it. There are so many topics in the statute that are supplemented or added to by federal labor contracts that if you don't, if you have an issue and you don't research the statute, research the case law, look at the regulations, and apply those to your labor contract or look at your labor contract, you won't do an issue that you have to give advice on proper justice. And finally, as the slide indicates, there's an executive order, 13522. That executive order encourages agencies to get their labor organizations involved pre-decisionally before they make a decision which affect the conditions of employment of the folks in their collective bargaining units. You can easily find that executive order if you use one of the searches that are available to you on the internet. But if not, that executive order was published in the Federal Register, volume 74, number 238, on Monday, December 14, 2009. So if you took that information and put it in a search, I'm sure that you'll come up with a copy of the executive order and you can study it on your own. It's a piece of labor relations, but we don't have the time to go into it during this training. All right, take your statute and please open it to 5 United States Code 701. And that is the beginning of the statute, and it contains, as it says in its title, findings and purposes. And those are findings and purposes of who? The Congress of the United States. Now, I'm going to give you time, a little bit. I'll count to myself and give you some time to look at that section of the statute. All right, I would like you to, in particular, look at the very last sentence of that section and have it in front of you. But if you noticed while reading this section, the Congress specifically states in the statute that collective bargaining safeguards the public interest. They specifically find that collective bargaining contributes to effective conduct of the public's business, and it facilitates and encourages amicable settlements of disputes. And so those were, that's a section of the statute that was put there when the statute was passed and became effective back in 1979. Now, to the last sentence of this particular section 701, it reads, "The provisions of this chapter should be interpreted in a manner consistent with the requirement of an effective and efficient government." Now, that's a rather odd sentence if you don't try and read behind it and understand what the Congress was stating. To me, the Congress is telling the FLRA, they're telling the courts, that if you have issues that you have to deal with concerning the application of the statute, you should interpret it in a manner that fosters effective and efficient government. So I see it as a tool of interpretation that the Congress put in the statute to guide third parties when they have issues involving federal labor relations. Now, if you turn your statute, I'll give you a few minutes, turn it to section 7104 of the statute. So if you want to know about the Federal Labor Relations Authority outside of this slide, the first place that we would go to, as I said before, is the statute. And the slide reflects some of the things that are mentioned in the statute, but of course not all. You're limited by what you can put into a slide with respect to versus what's in the statute itself. But it begins in 7104. The title of it is Federal Labor Relations Authority. And then on it goes to tell us all about the Federal Labor Relations Authority. It consists of 3 members, no more than 2 from the same political party. They're appointed by the president but confirmed by the Senate. They can be removed, and on the basis of which they can be removed is in the statute for inefficiency, neglect of duty, or malfeasance in office, and their terms are 5 years. This particular section of the statute also tells us about the office of the General Counsel, and the General Counsel is appointed by the President, confirmed by the Senate. The General Counsel may be removed, unlike the members of the FLRA, at any time by the President, and the General Counsel serves a 5-year term. And our next slide is going to provide us with some additional information about the Federal Labor Relations Authority. Excuse me. Skipped ahead a little bit too fast. Our next slide does tell us about the powers of the authority, and here are the things that they take leadership on with respect to interpreting and applying the Federal Service Labor Management Relations Statute. And that's the statute we're looking at, and from now on, I'm simply going to call it the statute. So if you hear me say the statute, I'm referring to the Federal Service Labor Management Relations Statute. So under that statute, we have Section 7105. It tells us about the powers of the authority. And in studying those powers and understanding those powers is important. So the FLRA determines the appropriateness of collective bargaining units, supervises and conducts elections, resolves issues involving national consultation rights, compelling need, which is a piece of negotiability, bargaining in good faith, and there are issues that arise from the definition of collective bargaining that relate to negotiability. The FLRA deals with unfair labor practices, and they deal with exceptions filed from decisions of arbitrators, third-party arbitrators. And the FLRA also appoints administrative law judges, and the role of administrative law judges in the Federal Labor Relations Authority is to resolve questions concerning unfair labor practices. They may hold a hearing and issue a decision in order, a recommended decision in order on the unfair labor practice charge. And then there are regional directors that are appointed by the General Counsel through the FLRA's authority. And those regional directors initially address questions of representation, but they too, if there are exceptions filed or an appeal filed, then the FLRA itself would hear appeals from those determinations of the regional directors regarding questions of representation. All right, we have another slide on the FLRA because it's so important that we understand its duties and responsibilities and why it's there. And we've already gone over the fact that it has 3 members, and it appoints administrative law judges. Now, I'd ask you to turn and make sure you're at section 7105 and look at subsection D. And that tells us that the FLRA appoints administrative law judges, and that section of the statute also deals with the authority, or how they get their authority to deal with questions concerning unfair labor practices. It's delegated by the statute. The authority to delegate it from the FLRA is statutory. So, what are the basic duties of FLRA administrative law judges? And fundamentally, they conduct hearings and issue recommended decisions on cases involving alleged unfair labor practices. And if you look at 7105F, that's the reference to appeals from decisions of administrative law judges, and it's the reference to appeals from the initial determinations on the appropriateness of bargaining units by the regional directors of the FLRA. Now, the other entity within the FLRA, and it's an entity that we don't have time and won't be able to go into in any depth at all, is the Federal Services Impasses Panel. And what do those folks do? The Federal Services Impasse Panel is an entity within the FLRA that assists parties in resolving bargaining impasses and can order the parties to adopt certain contract provisions relating to conditions of employment of unit employees by decision and order. So that tells us about the Federal Services Impasse Panel. And then the Office of the General Counsel, what does the office do as in practice? They operate under the direction of the General Counsel, and the General Counsel has direct authority over and responsibility for both the headquarters staff of the Office of the General Counsel and field staff of all regional offices. The Office of the General Counsel promotes effective labor management relations in the federal sector, and they do that by investigating alleged unfair labor practices, prosecuting them when it's warranted, conducting union elections, and otherwise determining representation matters. And they issue guidance and provide training to federal managers and unions, labor relations specialists, EA specialists in the statute. And they also provide alternative dispute resolution services through that office. And finally, they have on their website, and the website of the FLRA is at flra.gov. And it's just a resource for anyone listening to this training. And it's an important resource, and it's important that you go to that website. It's important that you examine and explore the drop-down menus. There's so much information that's valuable for agencies and labor organizations to need to know that's sitting there for our use and application. For example, if you went to the General Counsel drop-down menu, you will find, among other things, an unfair labor practice case law outline. So if you find yourself involved in an unfair labor practice, boy, is that a great spot to go to begin your research. That office also has issued a representation case law outline. Knowing that it's there, you can click on it, and you can do a Control F search and find out all kinds of information about the issues that you may be dealing with. And finally, they even have a representation case handling manual, which is extensive and lengthy, again providing all kinds of information for parties to look at, to study, and to learn from. Now, on we go to the role of third parties in federal labor relations. We've already talked about the FLRA. We've talked about the Office of the General Counsel and regional directors. And now I'll turn to arbitrators. And an arbitrator is what? He's an impartial, or her is an impartial third party to whom parties to an agreement go to do what? To refer their disputes for resolution. Arbitration types include grievance arbitration, or that's sometimes called rights arbitration, and arbitrators also conduct interest arbitration. Now, you can get a list of qualified arbitrators through the next bullet point organization listed here, through the Federal Mediation and Conciliation Service, or some parties to contracts, and there's nothing that prevents this, have developed their own list of arbitrators from which they choose by the procedures which they develop, and ordinarily those are put into the parties' collective bargaining agreement. And there are other private sources that provide for lists of arbitrators. Now, with respect to the bullet points and how they interrelate, here's just one point. Can I go from my impasse at collective bargaining and skip the mediation step or bypass the Federal Mediation and Conciliation Service, which is one form of mediation that's available to parties, that office? And can I go directly to the impasses panel? The answer is no. The parties must engage in some type or form of mediation as authorized by the statute before they skip and jump off to the Federal Service's impasse panel. And finally, and I thought this was interesting, which is the Department of Labor has a role in federal labor management relations, and you'll find that outlined at 5 United States Code 7120. And what do? They issue regulations, and labor organizations all file certain reports with the Department of Labor. Now, I'll also stop to discuss impasse, since I mentioned that previously. So what is it? If after negotiations and third-party mediation, unions and agencies are unable to reach a voluntary agreement in bargaining, either side, or the parties jointly, may request assistance from the Federal Service Impasses Panel. Now, again, we don't have the time to go into everything that the Impasses Panel does. That's the subject of another training session. But I will tell you this, at flra.gov, if you explore the drop-down menus under Federal Services Impasses Panel, lo and behold, what you'll find is a guide to dispute resolution procedures used by the Federal Service Impasses Panel, which you can download and which you can explore as you have the time to do it. Now, this Section 5, United States Code 7102, I'd like you to be sure that you have your statute in front of you and your labor contract in front of you. And if you read that section of the statute, here are some of the things that it says and gives to employees as protected rights. That statute is a form of protection to employees with respect to labor relations in the federal sector. And some of those rights are outlined on our slide. But there's a very great deal more that's involved, and I'm going to explore some of it now. What kind of activity, in reality, is protected by this section of the statute? And I apologize for reading and giving you case citations in the fashion in which I'm going to do it, but we found out through experience that if we put case citations on a slide and there are names on them, in the modern era, in an era where we're concerned about cybersecurity, you could end up getting an encrypted slide, which you won't be able to look at. So I'm going to do some reading. I prefer not to do it, but that's why I'm doing it. There's a very good practical reason. So one of the things protected is the right to seek union assistance, pursue grievances, and obtain union representation when dealing with the agency and matters affecting the employee's conditions of employment. That's protected by the statute. That's an example. Another example, exercising and asserting a right under the agency's collective bargaining agreement. That's protected by Section 7102 of the statute. Still another example, asserting a right under the statute is protected by that section of the statute. And you probably didn't realize this, but I'll read this one to you. Employees have the right to discuss the collective bargaining agreement and other representational matters in the workplace during, and this is important, non-duty time when there is no disruption of work. And the citation to that is Naval Air Station, Alameda, California, 36 FLRA 705. Now, I just mentioned non-duty status. So what does the FLRA define as non-duty status? And I know this definition is going to surprise some of you who are listening to the training. Periods of time during which the performance of the job function is not required, such as breaks or a meal period, fall within the category of non-duty status. And this is so regardless of whether the employee is paid for the break or whether management schedules or merely permits the break. And the citation there is a Navy case, and it's 61 FLRA 562. So you can see that this section of the statute sends us into a whole wonderful world of stuff that we need to know to navigate federal labor relations. Now, another question I have for you is solicitation of union membership protected by that section of the statute? And the answer is yes. The right to assist a union under 7102 includes the right to solicit membership on behalf of the union. And that case is Treasury Ogden Service Center, 42 FLRA 1034. Can I have an agency policy or an agency rule that prohibits solicitation of union membership by employees on the premises during non-duty time in the absence of showing some special circumstances? And the answer is no, because that the FLRA in its case law has determined that proposition. And that would be, if you had that in place, a violation of Section 7116A1 of the statute, which involves unfair labor practices. And the case citation there is an Air Force case out of Oklahoma, 6 FLRA 159. Now, how about solicitation? Now, we talked about solicitation in work areas. How about solicitation of membership by the labor organization in non-work areas? And solicitation in non-work areas, as well as work areas, is permitted where the employees being solicited are also in a non-duty status. I want to make that clear, non-duty status, absent disruption of the activity's operations. And that's a Bureau of the Census case, 26 FLRA 311. Now, how about this one? Gathering evidence or in support of a ULP charge or investigating grievances. Is that a protected right under 7102? And the answer is yes. And that case is Department of Justice, 18 FLRA 831. And also a Defense Department case, 21 FLRA 849. Now, how about publicizing the labor organization? Is that a right protected under 7102? And the answer is yes. Under certain circumstances, the labor organization can handbill or pass out literature, and those are rights that are protected by the statute. I'll give you some citations. An Air Force case, 29 FLRA 1044, and a dependent schools Department of Defense case, 21 FLRA 757. Now, how about if the labor union employee goes out and gives an interview to the press? Is that a protected right? And it is. And the case there is Bureau of the Prisons, Danbury, 17 FLRA 696. So in reading you all these FLRA cases and giving you all these citations, I'm also emphasizing the point that you need to know the statute, you need to know the FLRA regulations, you need to know your own contract, and you must explore FLRA case law if you're to navigate properly the Federal Service Labor Management Relations Act. And if you violate any of an employee rights under this section, it is a violation of 7116A1 of the Federal Service Labor Management Relations Statute. That is the section of the statute that deals with unfair labor practices. And we will talk a little bit about unfair labor practices as we proceed, but I thought it would be good to connect the fact that you violate this section of the statute, either hopefully not purposefully, but perhaps unwittingly, and you end up in an unfair labor practice proceeding. That's the section of the statute that you might be found to have violated. All right, on to definitions under the statute. And first of all, we've corrected this. You probably got a slide that did not have that small a in parentheses, and we apologize for that. It's there now on the screen, and it's more appropriately points you to the section of the statute. Now, 7103A1, just as an example of how important this definition section is. How do I find out whether my agency is even covered by the Federal Service Labor Management Relations Statute? If you went to the definition, and I would encourage you to do that as you have time, you will find agencies covered by the statute, and you're also going to find agencies who are not covered by the statute such as the Federal Bureau of Investigation. Now, 7103A9, please turn to that section of the statute and have it in front of you. And if you read it, and you read it carefully and slowly, what do you find out? What you find out is a grievance is defined as a complaint. And it's a complaint that involves a whole lot of matters, with the word matters not being defined. So if you look at that definition, what do you conclude? You conclude that grievances can encompass a very broad categories of bargaining unit employees' complaints. And that's the point of having you take a look at the definition of grievance in this definition section. There's a definition of federal supervisor, who under the statute and what types of persons' positions are considered to be supervisors under the statute. And the very next section contains a definition of federal management officials under the statute. And I'm going to briefly ask you to go to A10, where we find the definition of federal supervisor as it relates, let me be clear, as it relates to the Federal Service Labor Management Relations Statute. There may be a definition in some other statute that differs from this one. The same is true of management official. There may be a definition in some other statute, separate and apart from the Federal Service Labor Management Relations Statute concerning management officials. But now that you're at the definition of federal supervisor, you find what? 13 indications, or indicia as they call them, of a supervisor under the statute. You need only possess one of those. Okay, I'm a supervisor, and we want to see if I'm excluded from the statute. And I possess one of the indications of authority that are in that definition. I only need one of those, but I must exercise that authority with regard to the one indicia over an employee. And most importantly, if you look at that definition of the statute, it says that I must be able to make effective recommendations to upper level management concerning that employee that I supervise, and I must consistently exercise independent judgment to be a supervisor under the statute. Now, there are secondary indications. Suppose, for example, you're in a proceeding and you're trying to prove that someone is either in or out as a supervisor under the statute. There are some secondary indications of being a supervisor, and these are derived from FLRA case law. Amongst others, the person participates in management meetings and attends supervisory training, has the authority to grant time off to employees, though standing alone, the authority to grant leave is not dispositive. And another secondary indication that doesn't derive from that particular definition is evaluating employees. And the FLRA has determined that in some instances, evaluating performance can serve as the basis for supervisory status. Again, you need only supervise an employee or one employee to meet the definition of supervisor. Some of you may have questions. You're listening in, and you're in the interior of the country, and you're with an organization that employs seasonal supervisors. And the question is, are seasonal supervisors under the statute? The answer is yes. That's a Forest Service case, 23 FLRA 349. What does it mean under that definition of supervisor to effectively recommend something? And I want you to think in terms of upper level management accepting or relying on your recommendation. That's the effective part of the recommendation. They accept it or they rely on it on a regular basis. I'll give you some examples of where effective recommendation, think in terms of acceptance or reliance. So I'll give you an example of where the FLRA found that the person wasn't a supervisor. The person had made 3 recommendations to upper level management, and upper level management had only relied on 2 of them and accepted 2 of them. And the FLRA said, that person is not a supervisor. And that case is West Point Elementary School's 6 FLRA 70. If upper level management takes the recommendation of the supervisor or person that we're trying to determine is a supervisor, and they do what? They independently evaluate the recommendation. So John made the recommendation, and now I go off and do my own independent evaluation, or I do my own independent investigation, and I'm the upper level manager. That is not something that will lead you to believe that you've made an effective recommendation. And consistently exercise independent judgment under the statute means it's a factual determination. So the FLRA will make that determination based on the facts of each case that is in front of them. And we're sometimes asked the question, can team leaders be supervisors? And the answer is a maybe. And you would apply the same factors that we just discussed about supervisors to the duties and responsibilities of a team leader to determine whether or not they rose to the status of supervisor under the statute so that they would be excluded from a collective bargaining unit. Now, job titles are not dispositive. So the fact that you give somebody a job title and they're supervisor 1 is not dispositive of the FLRA. They're going to look to the duties of that particular person. All right. There are a couple of examples, or at least one example of where they found supervisory status is where an individual interviewed candidates for hire and interviewed all of those candidates, and then made a recommendation as to who should be hired, and upper level management did what? They relied on that recommendation, and that person was determined to be a supervisor under the statute. Now, turning to management officials, and that definition of management official, what do? They formulate, they determine, and they influence what? Agency policy. And those are the 3 criteria. What does that last one mean, influence? It means really to obtain a result with respect to policy. So they pushed for the agency to adopt a certain policy, and the agency adopts it. And so what have they done? They've influenced agency policy, and that is how a management official is defined under the statute. Now, bad news, most subject matter experts who do not recommend anything about policy are not considered to be management officials under the statute. And that's a Navy case, 7 FLRA 172. If you simply help implement policy, you don't meet the definition of management official under the statute. Now, let's go on to take confidential employee, and you look at the definition in A13, and it's somewhat of an enigma. And sometimes agencies think that, well, I have this secretary, and I discuss all kinds of matters with the secretary, or administrative assistant. I discuss all kinds of matters. And the focus of whether or not a confidential employee is confidential is, do they have a confidential relationship concerning what? Labor relations. And secondly, does that person that they have that confidential relationship with have a significant role in the agency's labor relations? And what does that mean? I'll give you some examples. Advising management on negotiating positions on proposals at the bargaining table, preparing for arbitration cases, consulting with management concerning the handling of ULPs, participating in contract negotiations, and deciding grievances. And those are all indications of labor relations responsibilities of the person that we're trying to determine as a confidential employee, whether they should be excluded from a bargaining unit because they have this confidential relationship with an upper-level manager who has significant responsibilities concerning labor relations. So, I'm going to give you one interesting example of a person found to be excluded as a confidential employee. An engineering technician who worked for a director. The director was the second step grievance official, negotiated with the union, responded to proposed disciplinary actions, and the tech edited the director's responses to grievances, had prior knowledge of grievance responses, proposed disciplinary actions, promotions, and awards, and that engineering technician was determined to be a confidential employee as defined by the statute. That case is Fort Rucker 60 FLRA 771. And there's also one other example. An employee who consulted and discussed with an HR specialist about the agency's response to union information requests and to FOIAs under the Freedom of Information Act was also determined to be a confidential employee. In that case, is National Credit Union Administration, 61 FLRA 349. Now, the final definition here, and the reason it's there are conditions of employment, that, folks, is what we bargain about in the federal sector. That's what it boils down to. We bargain about the conditions of employment of employees in the collective bargaining unit. And so you want to read that definition very carefully, because it too is a very broad definition, and there's a lot of wine that you can pour into the bottle of conditions of employment, but with some exceptions if you look at that definition. And they're listed there. And one, the very first exception, if you just think about it, is the Hatch Act. We don't bargain about Hatch Act matters. The next exception is we don't bargain about pure classification matters, but you better read the FLRA case law because there are plenty of nuances about classification matters. And we don't bargain about matters to the extent, and listen to what I just said, and that's what the statute says, to the extent that the matter is specifically provided for, and notice the word specifically, by federal statute. And those two words create some room and give discretion to agency officials with respect to certain conditions of employment, because the statute doesn't cover it totally, and the topic is not specifically covered by the other federal statute. Now, please have your statute open to 7111 and 7112. The statute prescribes procedures for secret, or provides rather, for secret ballot elections. The statute provides criteria to be applied by the authority to determine if a bargaining unit is appropriate. And you'll notice that the slide says we don't ordinarily sit and negotiate about who's in a unit and who's out of the unit, who's excluded and who's included. That's for the FLRA to determine. But there's one nuance that I thought I'd make you aware about, and that's that you may be involved in an election situation. And it may be that you're offered the opportunity to sign a pre-election agreement by the FLRA. And if in that pre-election agreement, you may be signing off on who's going to vote, who's in this election and included in the unit, and then you're going to have the exclusions in that agreement. But the FLRA is going to closely supervise you, and the inclusion and exclusion factors are going to be applied while you're being supervised. So this isn't a case where you sit down and you say, I'll give you 2 of these, but 4 of those, and they're in the unit and they're out of the unit. That's not how it works. 7112B and A are important. They tell us more about gaining exclusive recognition. And the FLRA makes those determinations in response to a representation petition. And there are various kinds of representation petitions. It could be that you have a bargaining unit and you're just not sure anymore who should be in it and who should be out of it, and there might be a unit clarification petition filed. There are instances where the agency is no longer sure whether this is an active collective bargaining unit, and an appropriate representation petition would be filed. So you've got to be familiar with 7111 and 7112 in order to properly deal with questions concerning who is included and who is excluded from bargaining units. This slide, next slide, gives us a definition of a bargaining unit. It's a grouping of employees that the union represents or seeks to represent, and that the FLRA has found to be appropriate for collective bargaining purposes. And the statute itself, if you look at 7112, tells us that a unit may be established on an agency, plant, installation, functional, or other basis under the statute. It's almost a self-explanatory slide, so I'm moving on to this one. And I wanted to spend a little bit of time on this particular topic, so be sure you have 7112 in front of you. I'm often asked the question, and we're going to turn to our labor contract. I'm often asked the question, well, how do I know who's in my collective, my union? And that's where your collective bargaining agreement comes in handy. And normally there is in a collective bargaining agreement someplace. I've often found them to be at the start or the front of collective bargaining agreements. And so when you have time to explore, look for what's entitled a recognition clause. And in the contract I have, this tells me, and it mimics the certification issued by the Federal Labor Relations Authority, who's in the bargaining unit and who's excluded in the bargaining unit under this particular collective bargaining agreement. And that is how a contract can tell you who's in and out of your particular agency's bargaining units. And of course, I can't say enough about you should approach, if you've got other questions about who's in and who's out, always be sure. You've got experts there, labor relations specialists, EA specialists, LMER specialists. Develop relationships with one another and with them as you have questions. That's the first place you should go if you have an issue you're not sure of. Have a relationship, a good relationship, and approach those people. They know the law, they know it well, and they can give you good, sound advice with respect to the issue that's bothering you. All right, now, this particular slide tells us the criteria that the FLRA applies to determine an appropriate unit under the statute. And it boils down to 3 factors: community of interest amongst the proposed bargaining unit employees, effective dealings with the agency, and efficiency of operations of the agency. And what in the world do these things mean? Community of interest, I want you to think in terms of sharing. Community of interest involves a community of sharing of interests between employees in a bargaining unit. And here are some of the things that indicate there's a community of interest. They're part of the same organizational component of an agency. They support the same mission. They're subject to the same chain of command. They have similar or related job duties and titles, are subject to the same general working conditions, are governed by the same personnel and labor relations policies. Additional factors, there's geographic proximity between these employees proposed to be in a bargaining unit, unique conditions of employment amongst all of the people that might be in the particular unit, distinct local concerns, there's a degree of interchange, and functional or operational status. Those are all factors that the FLRA is going to look at in determining on a case-by-case basis, case by case, whether or not there's a community of interest among those employees. How do they determine effective dealings? Here are some of the factors. Efficient use of resources, the parties' past collective bargaining experience, the location and scope of authority of the responsible personnel office, the limitations, if any, on the negotiation of matters of critical concern to conditions of employment, and the level at which labor relations policy is set. In looking at the cases, it appeared to me that organizational independence of this unit that sought to be organized and the degree of independent authority of that organizational unit's agency head are very critical factors that the FLRA looks at in determining whether there will be effective dealings with an agency and that it's an appropriate bargaining unit. With regard to efficiency of operations, here are some of the factors that the FLRA applies in determining whether or not it's an appropriate bargaining unit. Factors such as the impact of the proposed unit on the agency's operation in terms of what? Cost, productivity, and use of resources. Those are things the FLRA looks at in making a determination whether there will be efficiency of operations of the agency if they determine it's an appropriate bargaining unit. So they'll be looking at all of these three factors and the individual pieces of those three factors on a case-by-case basis in making the determination of whether or not the proposed unit is an appropriate collective bargaining unit. Now, there are certain types of employees that we already discussed that cannot be in a collective bargaining unit because the statute defines them out. And if after looking at all of the factors and applying the factors to determine whether or not somebody is a supervisor or whether somebody is a management official, and we determine that they're not, or the FLRA determines they're not, they cannot be in a collective bargaining unit. In fact, the law is pretty clear. Managers and supervisors can't be in a collective bargaining unit with one exception, and that goes back to when the statute was passed. There were a few collective bargaining units that were represented by unions who traditionally serviced managers and supervisors, collective bargaining units in the private sector, and those folks were grandfathered under the statute. So you may occasionally run into, although it's rare, a collective bargaining unit that has some managers and supervisors in it, and it's really historical. All right, there are other people who don't meet the definition of employee under the statute. 7103A2, for example, members of the uniformed services are defined out of bargaining units. However, off-duty military personnel are not. So on the one hand, the statute says that members of the uniformed services are not employees on the statute, but on the other hand, if I'm off-duty and in an off-duty status, I could be found to be included in a collective bargaining unit. Aliens who work outside the country, the statute defines them out. On the other hand, registered aliens working within the United States have been found by the FLRA to be eligible for inclusion in collective bargaining units. Teachers employed by the Department of Defense dependent school system are employees who are included in collective bargaining units. Now, there are some folks where the FLRA is, by their case law, determined cannot be included in collective bargaining units. For example, VISTA volunteers. That's one that folks who are my age would have heard quite a bit about, VISTA and VISTA volunteers. And they're denied employee status under that statute that they work under. So that particular statute involving VISTA volunteers does not allow them to be eligible for inclusion in an appropriate collective bargaining unit. Another example is recruits who've been offered positions, but pending successful completion of pre-employment examinations, those folks may not be included in a collective bargaining unit because they don't meet the definition of employee under the statute. And another example is purchase order vendors are not employees and cannot be included in an appropriate bargaining unit. Now, I've emphasized to you that you need to look at the statute. You need to look at your collective bargaining agreement to understand federal labor relations. You need to look at the FLRA case law to understand and operate within federal labor relations. You need to be familiar with the executive order that's currently in place. And I told you that the FLRA issues regulations, federal regulations. Those are the acronym frequently used is CFR, Code of Federal Regulations. And the FLRA, if you go to their website, flra.gov, and look for FLRA regulations, drop-down menu, boom, all kinds of regulations that you must read and you must be familiar with. And in some instances, the regulation is not very clear, and because it wasn't very clear and there's room in it for interpretation, then you have to turn to the FLRA case law to understand what it truly means. So again, all these things are pieces of a puzzle working together, and they're defining for us the federal labor relations, and they're defining for us the statute. So I can't say enough about knowing as much as you can about the subject matter of these pieces of the puzzle that I just spoke about. Finally, with respect to appropriate bargaining units, does the size of a bargaining unit have anything, does it impact and a decision regarding an appropriate unit? And the answer is yes. In one instance, the FLRA found that a unit of 4 was an appropriate bargaining unit. That's 82nd Training Wing, 57 FLRA at page 154. But the FLRA seems, if you read their cases, to avoid unit fragmentation when they're determining if a bargaining unit is appropriate. And there's another case where there was a possible bargaining unit of 20 some odd employees where the FLRA determined because of well, it's under the topic of size because they talked about 21, and they determined that was not an appropriate bargaining unit. So size does matter in federal labor relations. All right, we now have time, and we've left time to answer some of your questions. I want to say a few things about the questions. Can't possibly answer them all, and that is simply not going to happen.
Okay, this question is in reference to slide number 11. gaining exclusive recognition, 5 USC 7111 and 7112. What does an employee engaged in personnel work in other than a purely clerical capacity mean?
Oh, that's a really good question. Let me get to my slide. I don't know who asked it, but it's a question. It's a question that has troubled us ever since they passed the statute. And here's the key case, folks. It's a VA case involving the Veterans Administration, 66 FLRA 522. And I'm going to read back, because this is such a good question, some of the factors that the FLRA looks at to determine whether or not an employee is engaged in personnel work in other than a purely clerical capacity. First, the character and extent of involvement of the employee in personnel work is more than clerical in nature. Second, the duties are not performed in a routine manner. Thirdly, and I think most importantly, if you look at the case law, that employee exercises independent judgment and discretion with respect to the matter over which their position has authority. But so independent judgment and discretion is extremely important. There are a whole bunch of nuances, but let me just deal with one or two of them, since this question is such a good one and worth further exploration. That personnel exclusion extends beyond your internal HR. And it can include employees whose work directly impacts staffing and the overall work environment in an agency. And look to a Department of Transportation case, 63 FLRA 356. And I'll give you a few examples of where they have found a person to be excluded from a bargaining unit as coming within this statutory exclusion. Here's one of them. An employee advised the FAA on the impact of new technology on how many air traffic controllers the agency needed to employ, and made recommendations about the agency's organizational structure. That's big stuff. That resulted in the relocation or transfer of over 1,000 employees. That tells you, wow, this person made a recommendation affecting a whole lot of the people in the agency that was relied upon. And under those facts and circumstances, that person would be excluded from a collective bargaining unit. One more example. Analysts who conducted, quote, most efficient organization studies about whether work should be contracted out and made recommendations. And the result was what? The result was a reduction in the number of personnel after they did their studies, telling you that what? They exercised independent judgment and discretion with respect to what? Reduction of personnel. And it was relied upon by that particular agency. That's an Army case, 36 FLRA 598. Next question.
How long do you have to wait for, excuse me for a moment.
By the way, we've had some really good questions come in that were sent to us prior to the training session. I'm going to do my best to answer those, and but you've got to understand that if you send me a question and it involves I'm appearing before some third-party agency and I want your advice about that, it's something that I'm not likely to answer in a training session. It's a very limited concern to a broad audience. Other questions that we have?
Okay, how long do you have to wait for a union to request mediation before implementing?
A reasonable amount of time. What's reasonable has been defined by FLRA case law, but you have to wait a reasonable amount of time.
What is an impasse and how does it occur? And this is in reference to slide number 8, the role of third parties.
Let me see if I can even back up to that slide. Oops. All right. I'll be with you in just 1 second. And I'm going to read to you. And this definition of impasse, I candidly admit, came from the FLRA.gov website. So if you want to know about these things, it's real important. They've just done a wonderful job of giving us tools to apply to the practical issues and the day-to-day things that we have to deal with. So here's how they define it. If, after negotiations and third-party mediation, unions and agencies are unable to reach a voluntary agreement in bargaining, either side or the parties jointly may request assistance from the Federal Services Impasses Panel. That's it. That's the definition that the FLRA gives us about what is an impasse. Was there a second piece to that question? I'm not certain. No. All right. I'm told no. Other questions?
How does the FLRA determine if an employee acts in a confidential capacity to an individual who develops or implements labor relations policies?
That's another good one. And let's see, that would be, got to move ahead to that one. Oops. That's the definition. So open up your definitions in your contract and go to A7103A13. And I do apologize for the fact that the copy that you all got in advance of this didn't have that A in there, and I apologize again, but it's there now. So let me turn to that particular section, and I should be able to give you an answer that you can apply in dealing with the issue that you have. The FLRA, they always have tests for us to apply to our fact situation. And in this case, the FLRA determines if an employee acts in a confidential capacity to an individual who develops or implement labor management relations policies by applying a labor nexus test. And what does that thing mean? To determine if an employee acts in a confidential capacity to an employee who develops or implements labor relations policies, here's what they do. Under the test, the employee is confidential if there is evidence of a confidential working relationship between an employee and the employee's supervisor or manager, and this is important, and the supervisor or manager is significantly involved in labor management relations. Now, there are also some, if you don't meet that test, after they enunciated that test, they also decided that even if you don't meet that test, here's some things that could lead them to determine that you're still considered to be a confidential employee. When in the normal performance of duties, the employee obtains advance information on the management position and contract negotiations, disposition of grievances, and other labor matters. Over here's the manager talking about labor relations managers, has access to and prepares materials related to labor relations. Those factors, outside of that test I just described, can lead the FLRA to conclude that the person is a confidential employee. And for that one, look to Office of the Solicitor, 37 FLRA 1371. And I know, how are we doing? All right. So we've answered as many questions and answers as we can fit into this particular section. Don't hesitate to continue to send them in to plr@opm.gov.
Lastly, we just want to say that there are some questions that we've received today that are more appropriate for parts 2 and 3 of the training, so we'll get to those questions for the next 2 sessions of the training. But that concludes part 1's questions today.
And now I'd like to make some closing remarks. Thank you for tuning in to part 1 of our webcast series. Please tune in next week, Wednesday, April 12th at 2 p.m. for part 2, where we will continue the overview of the Federal Service Labor Management Relations Statute. We'll send out a new link to part 2 session this afternoon. And please share your feedback with us by completing the evaluation that was included as a link with your email containing the webcast instructions. We strongly encourage you to complete the survey. As the future will have it, there is going to be more and more agency training done by webinar, and your suggestions about how to improve that type of training will be invaluable, not just to OPM, but really across the board. And we review those responses. Believe me, I might even get reviewed on those responses to see how we can improve future training. And we also look forward to your suggestions for future topics. We'd like to make sure that we have an accurate count of all attendees. So if there were multiple viewers who watched the webcast from a central location, please be sure to send us an email listing the total number who attended. And again, you would send that to plr@opm.gov. And we'd really appreciate that very much. And I personally want to thank you, and I enjoy doing the best that I can to share knowledge with you, and we thank you for joining us today.